Right, so section 21, this section's going to be really, really quick because we've lost the opportunity to use it. So we could still serve it until today, but at 5:30 that ended because hand delivery is only deemed served before 5:30, so you can't go there tonight and serve a notice, okay? It's gone, it's done. So we are now in this scenario. It's gone. But the ones that are still in force are still applicable. Now, how are we going to evict our tenants moving forward? This is what landlords' biggest concern was, the abolition of Section 21. Now, it wasn't my biggest concern because I did think to myself, let me ask a question. Who here has used a Section 21 notice in the past? But really, realistically, we only ever use Section 21 if a landlord wants to sell, if a landlord wants to move back in, or if the tenant is a pain in the backside, or if they are in rent arrears. Those are the only reasons. Landlords don't just think, oh, I want to evict my good tenant because that makes sense. They don't. But good old Shelter and everybody have got their hands on this, and this is what they want to happen now, and they don't realise what they've done. But I want to reassure you that you still have the right to evict tenants under the grounds that we've just talked about. Rent arrears, you want to sell, you want to move back in, or you want your family to move back in. But the reality is what they've done is they've made it really difficult for us. They've made the timescales longer, and they've put some restrictions in place so landlords can't do it willy-nilly. These are probably the most common grounds that we will use in the new world. And ground one, which is ground one at the moment, basically means you as the landlord want to move back into the property, or you want to move one of your family members in. That's ground one. There's a new ground that has been introduced, which is ground 1A, which means the landlord wants to sell. Now, with both of these grounds, you need to be very careful. You need to make sure that you only use them if you are genuinely looking to sell or looking to move back in. And the reason I'm saying this to you is because once you have evicted a tenant under these grounds, you cannot re-let that house for 12 months. But think about it. Let's say we evict a tenant and we genuinely want to sell, right? And we put our house on the market. Are you going to leave it on the market for 12 months? They're crazy. It should have been 6 months maximum, because a landlord might leave a property empty for 3 months and try and sell it. If you're unsuccessful at selling, then what are you going to do with it for the rest of that year? So it's just crazy. So what will likely happen is landlords will negotiate with tenants and come up with agreements and give them backhanders and pay them to leave because the restrictions are terrible. Because the penalties for this part of the legislation is whopping. It's up to 40k. Because they know, you see, because when the legislation was first talked about, I thought, oh, it's all right, we'll just tell the landlords to lie and we'll say they want to sell. Oh, there we go, we'll evict you on that ground. They know that landlords are going to do that, right? So they've put something in to stop that. So we must be certain that we want to sell or we want to move back in. Is it illegal to induce them to leave, like as in pay them to leave? You have to be really careful because there's two things. There's Protection from Eviction Act, and you also, under that Protection from Eviction Act forms harassment. And you have to be really careful. But landlords have come up with, hi, Mr. Tenant, I really want my property back. Look, I'm happy to pay you removal costs and anything that you need in order to move you on. How do you feel about that? Are you happy for us to work together and find a solution that works for us both? And the tenant will say yes. But why you've got to be careful is because if I actually went round and went, we'll leave, but I will give you £1,000 as well, you've got to be very careful that it's mutual. Because otherwise the tenant could then go and try and claim prosecution and harassment against you. But if you can mutually agree, because let's be truthful, how many of you have got good tenants? There's lots of good tenants, and they'll sit down and they'll negotiate with you if it can work for both parties. So it's not illegal, but you've just got to be very careful. Who were the people that said that they had limited companies as their properties? Right, well, you can't use ground one because the company's not a person, so it can't move back in, and it doesn't have family, so you can't use ground one. The only thing you can use is ground 1A. So no, if you transferred it to new ownership and new contracts was done, then no. I don't believe so. But if it's a loophole, they'll close it. But for those of you that do own in the name of a company, ground one's not available to you. And somebody said to me, well, what if the company is owned by me as a human and I am the only director and I want to move my daughter in? No, you're still not the company. You can't. Some bigger challenges that have come our way, and this is something that I want us all to take seriously here, is that there's been a change in rent arrears notice periods, okay? So if we look at where we're at now in the old world, that's about to change tomorrow, a tenant needs to be 2 months in arrears before you can serve a Section 8 with a mandatory ground. Mandatory ground is ground 8. They need to be 2 months in arrears. In effect, it's about 31 days in arrears, isn't it? Because if the rent's due on the 1st of April, by the 1st of May, if they haven't paid, they're 2 months in arrears. In the new world, 3 months in arrears. Now, in the current world, when they become 2 months in arrears, we serve a notice and they have 14 days to pay. And if they don't pay after those 14 days, we make an application to court. In the new world, 4 weeks' notice. So we've gone from a process as of today of 2.5 months in arrears before we can submit a court application to 4 months. Now, this is what concerns me for landlords. This is what concerns me. And let me explain why it concerns me even more. Not just because of the increase in the notice period, but because we've lost the opportunity of using Section 21. Section 21 very rarely needs to be heard in a court. It's done through the post, through something called accelerated possession. And it is only ever heard in court if the tenant makes a defence. So 95% of Section 21s are dealt with through the post, and you will get a decision through the post. Mr. Landlord, here's your possession order. Now, every single eviction has to be Section 8, which means every single eviction now needs to be heard in court, which means the court wait times are only going to get longer. At the moment, I think, depending on where you're based in the world, or in the country, should I say, you could be looking anything between 3 and 6 months, depending on where you are. Actually, in London, the wait time for a court hearing is 11. 11 months. Now, again, under Conservatives, they told us that they were going to reform the courts before they did this. Labour got in and they said, forget that. And there is conversation about digitisation of the courts, but we're nowhere near ready. So us, in this next period of renters' rights new world, need to prepare for this. And I honestly would stand here and say this to any single landlord now, unless you have got enough money to cover yourself in rent, should your tenant stop paying for about a period of 12 to 18 months, insure yourself. Get rent guarantee. I now say to all my landlords, rent guarantee is no longer optional, it is essential. Rent guarantee, our provider, we use a company called HomeLet, our provider have extended their period from 15 months cover, which is what it's been since COVID, to 24 months. Because they know it's going to take longer to get these tenants out now. And we don't know how long that will be. The policy that we incept would give you guaranteed rent for up to 15 months. So if the tenant didn't pay rent and we didn't get them out, they would cover you for up to 15 months. Now, they gave you that much amount of time because during COVID, eviction times really extended. It used to only be about 8 months, but they increased it to 15 months to ensure landlords were covered during the COVID crisis. Now, as of tomorrow, they've increased that even further to say that we will pay you, if you have a non-paying tenant, we will pay you up to 24 months of rent because they know it's going to take longer to evict them from court, to get them out. Your rent guarantee will just be a rolling contract anyway. Yeah, it will just run in line with the tenancy. They've had to make changes to their policies, just like we've all had to make changes. But also, there's some really great policies out there that will cover you for the difference of your rent increase, which I'm going to talk to you about later. But there's a lot of great cover out there. Because don't forget, it's not just the cost of the rent not being paid. The court fee itself is about £410. The bailiff fee is about £180. Then you need a solicitor to represent you because God knows if you go to court on your own now, you must be crazy because the new world, you don't want to end up in court and it gets thrown out. There are rent guarantee providers that will look at the tenancy file, make an assessment. I mean, if your tenant's been in arrears, no, they're not going to insure you while your tenant's not paying. But some of them will, yes. But honestly, on every single let moving forward, I think landlords should have it as standard now. It just should be part of the process. But have a look out there, shop out there. But just make sure you're getting the cover that you need. Okay, so we've talked about the rent arrears ground. So I now want to talk again about ground 1 and ground 1A. So there is a 12-month protected period where you cannot use ground 1 or ground 1A. So let's start with the easy solution. If you move somebody in tomorrow, on the 1st of May, on an APT, you cannot use that ground until 8 months have passed. Yeah? They've got to be allowed 8 months. Then you serve the notice of 4 months, and it will end 1 year later. So basically, they've had a 12-month protected tenancy. You all with me so far? Now, for existing tenancies, the question keeps coming up, well, when does that 12-month period start for tenancies that are already in existence? And the answer to that question is from the last signed tenancy agreement. So if you did a renewal in January, you can't serve that notice till August to expire next January. If you haven't renewed it for said period of time, then you're good to go. So it doesn't reset tomorrow. Does that make sense? Now, this is going to be more important than ever on everything that you as landlords do, but really particularly around when you serve notice, okay? Evidence is going to be required, and in order to be successful in eviction, all of your ducks are going to have to be in a row. And if you have one duck that's swum over there a little bit, you're in problems. You're going to face challenges. So you've got to make sure that your deposit is protected correctly. Once in force, you will have to be registered on the portal, and if you're not, you won't be able to use Section 8. You've got to make sure your safety certificates are complete, and if they're not because tenant hasn't allowed access, that you've got due diligence to show why you haven't completed your certificates because tenants refused access, whatever the case may be. You need to make sure you have a compliance pack completed. So one of the things that will come up now in the new world when notice has been served, they will ask you to prove that you served the written statement or the leaflet on the tenant. That will be one of the things they ask you. So make sure you're ready for that. They are also going to want to see communication records, arrears records, and the court will actually expect you to have tried to work with your tenants on a reasonable basis with payment plans and so forth before you proceed to eviction. But let's be truthful. 3 months' worth of arrears, we ain't working together, are we? If you haven't paid me for 3 months, you have no intention of setting up a payment plan. So just make sure that you're seen to be documenting all conversations and make sure that you keep it. There's a summary statement that I say at the end of this, but basically it's something along the lines of, our biggest challenge in the new world is not bad tenants, it's bad paperwork or lack of paperwork. That is so true. Because, if you've got bad tenants, well, we've got a problem. But if you've got bad paperwork, we're screwed. So it's really, 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 really important. There's also the restricted periods that we talked about briefly earlier, that if you use ground 1 or ground 1A, you will not be able to re-let that property again for a period of 12 months. Now, bear in mind, I don't know if it's happening in Liverpool, but it's certainly happening in Wolverhampton, that they now have a double council tax policy for empty properties. Is that happening here yet? 100% increase on empty properties. Like, are they really trying to kill us all off? It's crazy. This is a massive one, and it's £40,000 penalty. So they've got 2 new magic numbers. Their magic numbers are £7,000 and £40,000. They used to be £5,000 and £30,000, but now they're £7,000 and £40,000.